Good evening, everyone. My name is John Packer. I'm the Director of the Human Rights Research and Education Center at the University of Ottawa. Bonsoir, mesdames et messieurs. Je m'appelle John Packer. Je suis le directeur du Centre de recherche et d'enseignement de droits de la personne at the University d'Ottawa. It's my great pleasure this evening, or today, sorry, I'm addressing you from Barcelona, and so it's evening for me and daytime for you. It's my pleasure to be able to welcome and to declare open this session, which is in conjunction with our partners of Human Rights Watch and CLAIHR on this important report that's been produced, Canada Behind Bars. We will hear the description and the analysis which has been brought to bear, and I would add the imperative to act upon it in terms of not only respecting the rights of those affected, but in upholding the due applicable law in Canada. Let me, first of all, make some remarks on, or rather acknowledgement that though I am not now speaking from the unceded and unsurrendered Indigenous lands of the Anishinaabe people, in fact, our Human Rights Center is located in Ottawa, which is unceded and unsurrendered Indigenous land, and our university is specifically located in such an area. We not only acknowledge this fact, but it is our hope and aspiration that through the efforts of all those concerned and the beneficiaries and all the benefits that we derive from being able to share this space, that we will sooner than later achieve a reconciliation in full respect of the Anishinaabe people. It's my pleasure now to introduce the moderator for the session, which is Mr. Samer Muscati, who is a longtime Human Rights Watch advisor, and he's going to moderate the session. Samer is known to a number of people from his work, not only at Human Rights Watch, but also in the International Human Rights Law Program, at which he was a director at the University of Toronto. If I'm not mistaken, Samer, you're also a graduate of both the University of Ottawa and the University of Toronto. Is that correct?
Close. It was Carleton University, but University of Toronto.
Oh, Carleton. Okay. Another university in Ottawa, I think we can say, down the canal. And so without further ado, I'm going to pass the moderation now to Samer. My apologies that I'm unable to stay for this important session, because in fact I have to lecture now in Barcelona at the Catalan University Ramon Llull on specifically human rights, peace, and conflict resolution. So I will be spending my time thinking about some perhaps further, but still related subject matter. And I will only say that I regret that I can't join for this specific session. So thank you for your understanding. So without further ado, Samer, I give you the moderation and wish you a successful session.
Thank you so much for that warm introduction, John. And I know that you'll be with us in spirit, even if you go off to teach the class right now. As John mentioned, I'm Samer Muscati, and I'm the Associate Director of the Disability Rights Division at Human Rights Watch. I'd like to thank the organizers of this event for creating this opportunity for us to keep the spotlight on people in immigration detention. Some of the most serious human rights violations happen to those who are out of sight and out of mind. Every year, Canada incarcerates thousands of people in immigration detention, including people who are seeking safety or a better life, people for whom Canada represents hope and a home. But instead, many of these people are forced to endure some of the most restrictive conditions of confinement in this country, and they do so without a countdown to a date of release. Not only are these violations of international human rights law, but they also have a devastating effect on people's mental health. The immigration detention system stands in stark contradiction to the image many Canadians have of the country as a welcoming multicultural safe haven. Today, we will present you with more details about the immigration detention system, including findings from a report by Human Rights Watch and Amnesty International. We will also invite you to participate in our ongoing advocacy campaign. Without further ado, I'd love to present our panelists. Today we have with us Molly Joeck, who's an immigration and refugee lawyer. She completed her degree in law at McGill University before clerking at the federal court in 2013-2014. She then started her career at a small firm in Toronto before moving to Vancouver in 2017, where she has practiced with Edelman and Company ever since. She specializes in immigration with a focus on immigration detention. She's also completing a PhD at the University of British Columbia. Her research is focused on the intersection of gender and risk in the context of immigration detention. Recently, she has been working on a project with the Canadian Association of Refugee Lawyers focused on the conditions and location of immigration detention in Canada. We also have Professor Joeck and João Velloso, who is an associate professor at the University of Ottawa Faculty of Law. He works in the areas of criminal law and sentencing, immigration law, criminology, and social legal studies with a focus on the judicialization of social problems and the governance of security through the intersections between criminal law and administrative law. His research deals with the penalization of migrants, access to justice in detention, and the regulation of cannabis. Professor Velloso is a member of the Human Rights Research and Education Center and participates in various Canadian and international research networks. Today, we also have Hanna Gros, who is a researcher with Human Rights Watch, focusing on issues related to immigration detention in Canada, and author of our joint Human Rights Watch and Amnesty report entitled, "I Didn't Feel Like a Human in There, Immigration Detention in Canada and Its Impact on Mental Health," that was published in June of this year. Previously, Hanna worked as a researcher at the International Human Rights Program based at the University of Toronto's Faculty of Law, where she authored 5 major reports on immigration detention, focusing on children, persons with psychosocial disabilities, and issues of evidence testing and procedural fairness. She's also previously practiced immigration and refugee law in Toronto and worked with the United Nations High Commissioner for Refugees in Canada and South Africa. Thank you so much for joining us today. And Hanna, perhaps I'll allow you to start things off with a presentation on some of the key findings and recommendations of your report.
Wonderful. Thank you, Samer. Thank you to the organizers, and thank you to all the participants for joining us today. We prepared a PowerPoint presentation for you, so I'm just going to pull that up right now. Okay. Is that visible? Is that okay? Yeah, okay, wonderful. So I wanted to provide a quick overview of the immigration detention system in Canada, along with some key findings from our June report from Human Rights Watch and Amnesty International. But first, I'd like to start with a video of a person with lived experiences in immigration detention in Canada.
My life changed the day I arrived at Vancouver International Airport in 2017. I fled from Egypt to Canada to seek protection. I was arrested without charge. My belongings were taken, including the batteries for my hearing aids. My whole life, I have relied on hearing aids, but suddenly I was in prison, confused, scared, and unable to hear anything. Nobody told me how long I would be detained. I was finally released. My wife and 2 boys are still in Egypt. I haven't seen them in 4 years. I live every day thinking about them. My life.
So Abdulrahman Al-Mahdi was one of the 90 people that we interviewed for the joint report that was published in June. And in addition to interviewing people with lived experiences in detention, we also spoke with lawyers, academics, psychiatrists, and mental health experts, as well as government officials. And our report covered a range of issues in immigration detention listed here, from solitary confinement to indefinite detention, discrimination against persons with mental health conditions, and the disproportionate impact on communities of color. Our evidence was anchored in the lived experiences of people who were incarcerated in immigration detention, and our analysis was based on international human rights law and standards. As you can see here, our overarching recommendation was that Canada should get on the path to abolishing immigration detention, and that under no circumstances should a person for immigration-related reasons be treated in a punitive manner, including being incarcerated in jail or jail-like facilities. So I'm just going to zoom out a little bit and provide a bit of an overview on this system to explain, how we got to this situation where there's such widespread human rights violations in immigration detention. So we have a flow chart here that really provides a big picture overview. The Canada Border Services Agency, or the CBSA, is the detaining authority in the context of immigration detention. And the CBSA is empowered to detain non-Canadian citizens, including refugee claimants. So for example, Abdul Rahman was detained upon entering Canada and seeking asylum in this country. And usually CBSA officers detain people where they suspect that they may not show up for a hearing or for removal proceedings, or if people don't have the right identity documents. And CBSA can also detain people who they suspect pose "quote unquote" danger to the public. In a bit later, excuse me, in this presentation, Molly can provide a bit more detail about what these grounds actually mean in practice and how they're assessed. CBSA has the power to release detainees within the first 48 hours of arrest, and then immigration detainees have access to regularly scheduled detention review hearings, which are conducted by a tribunal. These hearings take place 48 hours after release, and then if they're not released, then there's another hearing 7 days later. And if they're refused release again, they have hearings every month. There is no maximum time limit for how long immigration detainees can be incarcerated. So they risk getting stuck in this sort of cycle of hearings month after month without getting released. And the longest instance of detention was 11 years, and it involved a man who appeared to have a mental health condition, and the government could not identify his identity. The CBSA has sweeping police powers, including, of course, the power of arrest, detention, search, and seizure. But the agency remains the only major law enforcement agency in Canada without independent civilian oversight to review policies and investigate misconduct. And as you can see here, for some statistics for immigration detention, the number of immigration detainees has increased every year since fiscal year 2016-17 until before the pandemic. And the vast majority of immigration detainees are held because authorities, again, suspect that they might be a flight risk. So between April 2016 and March 2020, just before the onset of the pandemic, the proportion of immigration detainees that were held for reasons of flight risk was about 83%. And again, Molly can provide a bit more detail as to what these grounds mean a bit later. So as I mentioned, the CBSA has full discretion over where immigration detainees are held. Between fiscal years 2016-17 and just prior to the pandemic, approximately 2/3 of immigration detainees were held in immigration holding centers, which resemble and operate like medium security prisons that are dedicated exclusively to immigration detainees. there are 3 immigration holding centers in Canada, and they're located in Ontario, Quebec, and British Columbia. So you can see these are the red dots here. So this is the one near Montreal, and near Toronto, and near Vancouver here. CBSA also incarcerates thousands of immigration detainees in provincial jails. So for example, in fiscal year 2019 to 2020, approximately nearly 2,000 immigration detainees were held in provincial jail, alongside criminally accused individuals who are awaiting court proceedings and criminally convicted individuals serving sentences of up to 2 years. Many of these provincial jails are maximum security facilities, and following the onset of the COVID-19 pandemic, CBSA has actually relied even more heavily on provincial jails to incarcerate immigration detainees. And you can see in this map that over the span of 3 years, so between fiscal year 2017 to 18 until just before the pandemic, CBSA used a total of 78 provincial jails to incarcerate immigration detainees. So all of the blue dots across the country here. A minority of immigration detainees are also held in other facilities like police stations, but these tend to be very short-term detentions. So although immigration detainees are not serving criminal sentences and they're not being held for criminal purposes, they're often treated like people incarcerated for criminal offenses. So they're handcuffed, they're shackled, searched, subjected to solitary confinement, and restricted to small spaces with rigid routines under constant surveillance. And of course, they have severely limited access to the outside world. In provincial jails, many immigration detainees are also confined to tense and even dangerous environments where they may be subjected to violence. And this is at the bottom here, just a quote from a person who was incarcerated in immigration detention. He said, "Many people develop mental health issues in jail. Most of the time, I would just lie there and I would feel my mind drifting, breathe circulated air. It's a place where you have to be very strong to avoid losing your mind and to stay the same person you were before. When I put everything together, all the pressure and being away from my wife and kids, it was very hard to take. I just prayed." There are various systemic issues that make it very difficult for immigration detainees to obtain release. So for example, although immigration detainees have access to regular detention review hearings, there are significant limitations for the tribunal that conducts these hearings. So adjudicators don't have jurisdiction over the site and conditions of detention, so they can't order CBSA to move an immigration detainee from a maximum security jail to a dedicated immigration holding center. Adjudicators are also not bound by any legal or technical rules of evidence, and they may base their decisions on evidence that they consider to be credible or trustworthy in the circumstances. And of course, this standard pales in comparison to the rules in criminal proceedings, which really should not be a ceiling but a floor in any context where deprivation of liberty is on the line. And of course, again, there's no limit prescribed in law to the length of time immigration detainees can be held in jail or other jail-like facilities. So ultimately, the immigration detention system works in such a way that authorities have a great deal of discretion and no independent civilian oversight. And this creates a sort of legal black hole and diffusion of responsibility. So for example, for immigration detainees who are incarcerated in provincial jails, they remain within the legal jurisdiction of CBSA, but the agency effectively relinquishes control over conditions of detention because jails are, of course, in provincial jurisdiction. And detainees also can't turn to the tribunal to seek transfer out of these provincial jails because the tribunal, again, doesn't have the power to order these transfers. And this at the bottom here is a quote by a Superior Court judge in one case involving an immigration detainee. And I thought it just captured the Kafkaesque nature of the system really well. So he said, as with Kafka's protagonist, Joseph K., no one knows why Mr. Scotland is detained. Our research also found that immigration detainees who are from communities of color, and particularly detainees who are Black, appear to be incarcerated for longer periods in immigration detention, and they're often detained in provincial jails rather than immigration holding centers. So for example, according to statistics that we received from the Canada Border Services Agency, we see here that the majority of immigration detainees held for 90 days or longer, or 180 days or longer, or 270 days or longer are from countries in Africa or the Caribbean. And immigration detainees with mental health conditions also face discrimination throughout the process. So for several reasons, they're more likely to be detained in provincial jails rather than immigration holding centers, which again are dedicated exclusively to immigration detainees. In provincial jails in Ontario, they're often placed in solitary confinement. They may also not be allowed to make independent decisions about their legal matters because the tribunal can appoint so-called designated representatives to act on their behalf as substitute decision makers. Finally, immigration detainees with psychosocial disabilities also face significant barriers to release from detention. And in the event that they are released, they're more likely to face onerous release conditions within the community, and this may lead to rearrest. So overall, put simply, authorities often view psychosocial disabilities as a risk factor. And instead of receiving vital support, immigration detainees with psychosocial disabilities receive disproportionately coercive treatment. And this was a quote from one of the people that we interviewed who spent time in immigration detention, incarcerated in the jail, and also placed in solitary confinement after he expressed some thoughts about suicide. He said, "I was just waiting and praying, trying to convince myself that it's not that bad. I was thinking they can't just leave me in here. I didn't feel like a human in there. I felt like a dog. The guards would just open the latch to feed me." And as I mentioned, in addition to interviewing people with lived experiences, we also interviewed many lawyers and advocates who are fighting for the rights of immigration detainees day after day. And one of them told me, if we truly believed that immigration detainees feel pain, anxiety, love, and hope the way that we do, incarceration would not be the solution. This could only be the solution if we truly believe they're not as much human as we are. And I thought that really summed up the system really well, and how far along we've come from a system that really truly recognizes people and as full human beings. And with that, I will pass it back to Samer. I think we have some questions prepared.
Thank you, Hannah, for that incredible presentation. It's really informative. And I thought perhaps, I see that we already have a question in the chat, which is fantastic. But perhaps before we move to the chat, I did want to take my prerogative as moderator and ask maybe 2 or 3 questions first, and then open it up if that's okay with our panelists. But the first question, perhaps, during these times of COVID, it's had an impact on so many parts of our lives. I just wanted to sort of ask our panel, what was some of the impact that we saw with COVID on immigration detention?
I can maybe say a few words about that, and then João, if you want to jump in with your observations. I mean, we did see a drop in the numbers of people in detention. Now, there's a few different ways to interpret this. One is it does seem like the immigration division was more open to releasing people, detainees. The immigration division shifted the way it considered conditions of detention. So before the pandemic, the immigration division had refused to consider conditions of detention, holding that was outside their jurisdiction. So if a detainee were to advance an argument along the lines of, I'm being detained in a provincial correctional facility. The conditions here are very harsh. I'm being commingled with convicted offenders. This is, conditions that are impacting my mental health. The immigration division's position towards that was we might have sympathy for that situation, but there's nothing we can do about it. When the pandemic broke out, detainees started advancing the risk posed to their health by the fact that they were in a carceral facility where the virus can spread really easily. And the immigration division explicitly took that into consideration when ordering release. So there is one way to read the drop in number of detainees, and that is that the division was ordering release more readily, and or the minister was consenting to release more readily. And I do think that was happening to some degree, but it's also important to recognize that the borders shut down, so there were simply fewer people entering Canada to be detained. So it's really unclear which of those factors is more important in accounting for the drop in the number of detainees. The other sort of main thing that happened was the isolation of detainees in detention, right? Which was true for everybody in carceral facilities. So lawyers were virtually unable to visit their clients. Detainees who were detained had to undergo 2 weeks of isolation. I believe they still do. So effectively solitary confinement for 2 weeks. They were cut off from friends and family members who may have been able to visit them before the pandemic. Before the pandemic, a lot of detainees participated in their hearings in person. Hearings all became virtual, sometimes by phone, sometimes by video. So, while virtual hearings can, I think, be spun as a way of facilitating access to justice, I think it's really important to remember that detainees can really easily be cut off from the outside world. And the pandemic showed us how quickly and easily that could happen. And I think that had a severe effect on the mental and physical health of a lot of detainees. So those are just a few examples of the impacts. João, you might have some more input on that.
Yeah, I will add a couple of things, but it's more or less on the same line. I think that there were two main factors on this. I'll try to share some data because it may help visualizing a couple of things, which pretty much reinforce with what Molly already mentioned. So like this is this idea of emptying the immigration holding center, but like there was two issues as we saw in the presentation of the reports, that it was not only the holding centers that are holding immigration detainees. So they moved some of they pretty much emptied the three main holding center nearby the airport, like Pearson, Trudeau, and Vancouver, but they transfer some of this population to provincial facilities. And actually a big impact that happened, it was, as I was showing the other slide, but I can start talking on this now, is the halting on deportation, because like the detention, it is part of the deportation machine. So this idea of flight risk is to attend the hearing, but also to executing a deportation, a removal order. So as they stop deportations, there was less need to use the detention facilities to keep people on hold, waiting for the deportation. And as deportation resumed in December 2020, like numbers of detentions start to go a little bit up again. And it's interesting to note, more in the same line as Moby said, that the borders were closed. And if you look to the numbers before the pandemic, roughly 60% of the arrests were made at the border, at the entry. Well, borders are closed, the arrests drop to 80%, to 8% only, and they start shifting to what they called inland arrests, that are issues dealing with the populations that are already in Canada as refugee claimants or permanent residents. So it changed a little bit the dynamic of detention. But again, as borders open, these numbers will more likely go back to the 56% again, and we may see the same pattern.
And if I could just add, I think, so as Molly and Giles said, the numbers of detainees have gone down, but we've also seen that for those detainees who remained incarcerated, the conditions became much harsher. And in fact, CBSA has relied on provincial jails more heavily since the pandemic began. But I do think that this sort of there is a unique moment in time with this pandemic. It really does provide us with an opportunity to to turn the corner and not go back to business as usual. So of course, it's very worrying for me as an advocate to contemplate the notion that we would just return to the high numbers of detentions that we had before the pandemic, because of course we've seen that there are viable alternatives to locking people up for an indeterminate amount of time and in some of the most restrictive conditions of confinement. So I think this really is a unique moment in time for advocates to really shed light on this issue and push the government to turn the corner on this.
Yeah, and Hanna, it's quite odd that provincial facilities in almost every province they release the pretrial detention community and they encourage early release in parole as much as possible during the pandemic, but at the same time they were accepting immigration detainees. So it's kind of a very troubling way of dealing with detention. They really realize that, well, people should not be in detention facilities serving administrative detention at all, or they should have an early release if they have access to that. But due to this kind of dual authority thing, that, well, it's CBSA that are managing what's going on with immigration detainees in provincial facilities. Like they didn't went out with the criminal detainees as they should. Well,
thank you all. That was a very informative response, and perhaps Hanna, we can ask you a bit more about the campaign around provincial facilities in a bit. But I also wanted to ask, I think oftentimes when people know that immigration detention is happening in Canada, they're quite curious in terms of why people are being detained. And I think from the statistics, we see that the most common ground of detention is flight risk. Just can you explain a bit what flight risk means in practice with some examples, if I can ask the three of you that as well?
Sure. So, I mean, I can explain from the perspective of a practicing lawyer. When someone is detained, the immigration division, so that's the administrative tribunal that, Hanna was talking about earlier, the CBSA has to establish what is referred to as a ground for detention. And yes, the most commonly applied ground is flight risk. Some of the others are danger to the public and/or that the person's identity hasn't been established. So one of those grounds has to be established in order for detention to continue at that first detention review. Flight risk refers to whether the individual is likely to appear for the next step in their immigration proceeding. So that might be an interview with the CBSA, that might be a refugee hearing, that might be a meeting where they're going to receive a decision on an application they've made. So what the immigration division is tasked with doing is making a finding on a balance of probabilities. So in essence, is it more likely than not that this person will not appear for the next step in their immigration proceeding? This is an unfortunately common ground of detention. And as you can probably imagine, it brings into play factors such as an individual's mental health, and a subsection of mental health is addiction. That's something we see really commonly in immigration detention, and sadly. And it's quite a thorny issue to watch the ways in which really vulnerable individuals, often suffering PTSD or other kinds of mental health, are held to this very challenging standard of flight risk or unlikely to appear. So I mean, I can give some examples, but João, or Hanna, why don't I let you speak a little more to that, and then we can go from there.
I'm just sharing the data on this. Sorry about that. And I'm not going to speak any further. I think Molly really covered this quite well, and with some examples, like the numbers are horrifying in a way, unlikely to appear. It's way over the top, as we also, and I also mentioned in the report. And if you add other bureaucratic issues regarding, simply examination interviews, identity, and suspected inadmissibility, which doesn't mean that there is an inadmissibility on grounds of criminality, which is already very easy to determine. Same thing for security, same thing for human rights violations. So this can be horrifying, and obviously, as Anna mentioned as well, raise a couple of questions regarding profiling, which is also very problematic.
Yeah, and if I could just add just some examples from the themes that I heard from people with lived experience. I think oftentimes people have a really hard time wrapping their minds around why they're being detained. I mean, we can explain the legal grounds of flight risk, but really what it comes down to is authorities don't believe you when you say, I'm going to show up for my refugee hearing. I'm going to show up for my meeting with CBSA. Even if I express fear of going back to my country of nationality, because I may very well face danger there, that doesn't mean that I am willing to break the law in Canada and evade removal proceedings, for example. So it's a really unique situation where authorities have the discretion to make the assessment about your intention to show up or not show up for a proceeding on a balance of probabilities. So is it more likely or less likely? And on that determination, deprive you of your liberty, potentially in some of the most restrictive conditions of confinement in the country, including maximum security provincial jails. So it's not a surprise that I've had clients myself who have asked me how long can I be detained here, and how in the world can I get out? How can I convince authorities that I do in fact have the intention of respecting Canada's laws? And in the meantime, I can't even tell them, how long they'll be in this situation, because there is no limit. So it just leaves people in such a helpless situation that it's not a surprise that their mental health is severely harmed. It's a very devastating circumstance to be in, day after day, month after month, for some people, year after year.
Yeah, I can add an example I came across recently. One of the ways, or one of the factors that are held against individuals on the unlikely to appear ground is their past quote unquote non-compliance with immigration laws. And that can be Canadian immigration laws or other countries' immigration laws. So as you can imagine, Canada will often receive non-citizens, refugee claimants who have spent time in the United States, because we share such a large border with the US. So I worked with an individual recently who had come to the US from Mexico as a child. So his parents brought him to the US. He was subsequently deported for reasons, that are complicated reasons as a youth. And he re-entered the US because that's where his family was. And he ended up in a cycle of deportation from the US and re-entry, because every time he was deported, he returned to the US in order to be with his family. And, later in his life, he's now come to Canada to try and seek stable status. And that past non-compliance with American immigration laws is held against him, with very little regard for the fact that there are many individuals like him who find themselves in countries like the US with no status, and they have no good option at that point. There was no path for him to status. He had no family and no connections in his home country. And it's a black hole for someone in that position. And when he came to Canada, that fact, the way he coped with that reality was held against him to justify detaining him for several months. And findings like that are very problematic for vulnerable individuals like that.
And on this, like, just a little step that makes things even more worse in a way is the credibility issue, because almost by definition, what immigration authority says are credible. So this idea of having reasonable grounds to believe to determine that something is valid or credible, like this applies to quite easily to immigration authorities, but this goes the other way around for detainees, because they may establish that they have some ID, some document, they are from that country, but authorities may assess this on the other way around and say, well, we still need to do further examination, we still don't have an ID, we still don't know from what country you came from, and so on. And you create these limbos and legal holes that may lead to endless detention.
Wonderful. We actually have some questions coming in from the audience. So if I think we'll turn to those. What role do you think activism has in ending immigration detention? And what can listeners do to advocate for change?
So that's a great question. We actually have a really good answer for that. For once, we're running an advocacy campaign now, jointly between Human Rights Watch and Amnesty International. Maybe I can just share my screen one more time here. Okay, there we go. And the campaign is called Welcome to Canada. We launched it in October of this year, so just last month. And our overarching message is that it's time for Canada to truly welcome people seeking safety or a better life, and everyone deserves to be treated with humanity and compassion. So it's very hope-based, in contrast to our findings about the devastating human rights violations in this system. And the focus of the campaign is the detention that happens in provincial jails. So as I mentioned, CBSA has the discretion to hold people in provincial jails. And the reason they're able to hold people in provincial jails is because they have memorandums of understanding or contracts and informal arrangements with each province of the country. And essentially, based on those contracts, CBSA can just transfer immigration detainees over to provincial facilities. And so what we're really calling for with this campaign is to cancel those contracts. And it turns out that those contracts have actually a really simple termination clause. And either party can basically provide written notice that they would like to exit the agreement, and with 1 year's notice, the agreement is canceled. So the rationale for our focus on this objective is that if these contracts were canceled, this would effectively eliminate the worst conditions of detention in Ontario, Quebec, and BC, and virtually eliminate detention in the rest of the provinces. This approach also helps us broaden our advocacy targets. So of course, because immigration detention is within a federal jurisdiction, traditionally our advocacy target was the federal government. But these MOUs and informal arrangements make clear that the provinces are in fact complicit in the human rights violations that immigration detainees endure within provincial facilities. And so we really want to draw attention to the complicity of the provinces as well. In terms of feasibility, again, the contracts have a very simple termination clause. So this sort of intervention or this change doesn't require any major legislative procedures. It really is just a matter of exiting a contract. And of course, for the informal arrangements, you don't even need to exit any contract. It's just a matter of ending that informal arrangement. There's, of course, a strong case under international law against punitive measures in immigration detention, again, because immigration detention is administrative. And so, of course, immigration detainees are not supposed to be subjected to punitive measures. Of course, in the context of provincial jails, it's undoubtedly punitive. And finally, again, we have a unique moment in time, I think, with the pandemic, because we've seen, as we mentioned before, a huge reduction in the number of immigration detainees, but a more heavy reliance on provincial jails. And so we really want to take the right turn with this fork in the road and make sure that we don't go back to business as usual. And so we've launched a dedicated website to this campaign. What we're doing is going from province to province, so coast to coast. We started with British Columbia, and we're really trying to encourage that province to exit from their memorandum of understanding with the Canadian authorities, with CBSA. And so we're hoping to really encourage each province to take this important step. And if you visit our website, there are various things various ways for you to also participate. We're starting with BC, but we will be moving to other provinces down the line. And yeah, we would love your support in this. Samer, I'm not sure if there's anything else that I missed there that you wanted to add.
No, I think that's you did a great job covering some of the advocacy around this. I'm not sure, Molly or Joe, if you had anything that you wanted to add on this point. Otherwise, I'm happy to move. Please go ahead.
Yeah, it's just a little comment, and bringing us a little bit back in time and to remember the awful violations regarding the context of security certificates. And there was a lot of reactions from civil society and courts, and we pretty much stopped using this form of detention and deportation in Canada after reactions from the public. So this was done in the past and to very particular circumstances, and I think we can definitely do it again.
Yeah, absolutely. And I think, something Hanna mentioned with our campaign, I think the focus really is on how the provinces are also complicit in this. I think oftentimes people don't know that immigration detention is happening in Canada to the degree that it is. And then complicating that is this shared responsibility where the provinces, assume no responsibility, despite that people are being held in terrible conditions in provincial jail. So we hope that through this campaign, at the very least, people will know the truth of what's happening here in Canada and help us sort of take steps to change that. I'll go to the chat again. We have a question to all the panelists. What are your thoughts on stateless persons in immigration detention? Do you think that they have different experiences given their unique circumstances? For example, not having identity documents. Somebody wants to take that question.
Sure. I mean, I can say a few things about that. I think stateless persons face all kinds of challenges in the immigration and refugee law system, and detention is certainly part of that. Detention can become prolonged for stateless persons. It's important to remember that some people are acknowledged to be stateless, whereas others are de facto stateless, and that's not yet apparent when they're detained. Their country of citizenship might be unclear. There are a lot of individuals who don't even know exactly where they were born or if they're entitled to citizenship. And the burden is often on that individual, or not often, the burden is on that individual to prove their identity. The minister is supposed to take steps to, I don't want to use the word assist, but the minister investigates an individual's identity. But the fact is, people will be trapped by the circumstances from which they come, which are completely beyond their control. So what I would term sort of de facto statelessness can often lead to prolonged detention for reasons beyond the control of the detainee. People who are acknowledged to be stateless, that's a slightly different scenario. If someone is not deportable, if we know that an individual can't be deported, they are not supposed to be detained. Now, whether that happens in practice is another question, but the Federal Court of Appeal has rendered a decision in recent times that should be interpreted that way. So, how it will be interpreted remains to be seen. But those are a few remarks I can make about the question of stateless detainees.
And I think, Molly, maybe you could also shed a bit more light on this, but in some circumstances, people do know where they're born, but their countries of nationalities don't acknowledge them as citizens. And they're so they're not able to get those identity documents. And so it's impossible for Canada to remove them because there's no proof that they are citizens of a particular country. And that often leads to prolonged and sometimes indefinite detention as well.
Absolutely. Yes, that is another issue. Not to mention, I remember when I first started practicing, I came across a case where an individual who was from Vietnam, but he'd fled with his family when he was a baby and had no proof of his Vietnamese citizenship and or non-citizenship as the case was. Nevertheless, he was considered to be Vietnamese by the Canadian immigration apparatus. And the CBSA tried to deport him twice. And when I say tried to deport him, I mean they escorted him on an airplane and flew to Vietnam. And on both occasions, the Vietnamese authorities said, you have no right to enter this country. You're not Vietnamese. And they turned around and flew back to Canada. And this man was still fighting for status years later after these two failed deportation attempts. So that person was clearly stateless for all intents and purposes. And yet the minister was determinedly attempting to deport him and attempting to convince the Vietnamese authorities that they should accept him. So you get some real, as you said earlier, Hanna, Kafkaesque circumstances that are caused by the fact that, yes, there's geopolitics at play. There's, the loss of identity documents. Many people have lost family members and just have no way of tracing anything. All these circumstances can make it really difficult for people in detention.
And the circumstances of some of these folks doesn't end, with the detention, because quite often these cases, they are released under very harsh conditions, and their lives in the country are far from being a free one after the detention period. Quite often, they have a lot of the restrictions, and that are very easy to breach, which means that they may go out and in detention quite often for forever. It's until the government grant them a particular status in the country. So it's awful.
Great. I guess our next question is, what are some of the obstacles to release from the detainee or their counsel's perspective?
There are so many obstacles to release. It's hard to know where to start. I mean, a detainee is tasked with finding what gets termed an alternative to detention, right? So somewhere else they can go where the factors that have contributed to their flight risk or danger, quote unquote, will be addressed. So what this means is the immigration division says, okay, I have found you to be a flight risk for the following reasons, like I mentioned earlier, maybe you failed to comply with rules in the past, or you breached some bail order or something like this. And you need to present me with an alternative to detention where I can see that these factors are going to be addressed. And for someone who often has just arrived in Canada or has been in Canada for a while, but may have been living on the margins of society for various reasons, setting up such an alternative is an insurmountable obstacle. It requires finding a place to live. So whether that be some sort of halfway house or recovery house, a home with a friend, a home with a family member, it requires having the resources and the connections to find something like that. Paying for it is another huge hurdle. And then setting up whatever other apparatus might be expected. So, I've seen cases where people are released with electronic monitoring. That's been something that's been covered in the news too, the increased use of electronic monitoring. Now, what our attendees might not know is electronic monitoring is not paid for by the government. So detainees who are released on electronic monitoring are funding that themselves, and it's quite expensive. So there may be detainees who could be released if they could pay for electronic monitoring, but they can't afford it. I don't want to argue that electronic monitoring is something we should be using on a regular basis, but I think it's important to highlight that financial means often differentiate people who can seek release from people who can't seek release. I can recount one story that I think is particularly horrifying. I worked with an individual who was being detained in a provincial correctional facility, so a maximum security jail. The conditions were really, really harsh, and he was struggling. He had no criminal conviction in his life. He had one pending criminal charge, and it was unclear how that was going to play out. And he had filed a refugee claim. And this particular individual had struggled with drug use in the past. And his flight risk was framed as being about his drug use. So I had assisted him to find a bed in a recovery society, essentially a place that would help him address any issues he'd had with drug use, because that's what the immigration division wanted to see. The problem was, to go to that recovery society, he had to be on social assistance. To qualify for social assistance, he needed to have a work permit. Now, he'd applied for a work permit, but to get a work permit, you need to undergo a medical exam. It's all quite elaborate, right? And I had written to the CBSA and said, you need to let this individual undergo a medical exam so he can get his work permit, so he can get social assistance, so he can be released. And the CBSA said, no, we're not going to let him leave the facility to do the medical exam. That's not, we don't have to do that. So I went before the immigration division and argued that this was grounds for release. The CBSA was obstructing his pathway to an alternative to detention, and the immigration division didn't seem all that interested in my argument. So I filed a habeas corpus application. And surprise, surprise, if the CBSA didn't get on the phone with me the next day and say, let's talk about this, how can we get your client a medical exam? And I marched forward with the habeas corpus application, and something like 3 or 4 days before the hearing, he got his medical exam. Now, it's important to bear in mind that, that wasn't going to change things overnight. From the medical exam, there was still going to be a time lapse until he got the work permit. And then he needed to do the paperwork for social assistance. But all the steps that needed to be taken in order for him to access his alternative to detention. And the only reason this was happening was because I happened to come across this case as duty counsel. A lot of detainees don't have a lawyer who's jumping through all those hoops on their behalf, and they can't do it themselves. A lot of them don't. English is not their first language. They might speak a bit of English or none at all. It's just completely unrealistic to expect detainees to be able to meet this bar for an alternative to detention.
I think that really, I'm sorry,
go ahead, Anna.
I was just going to say, I think that really highlights not only the level of discretion that CBSA has, they can just change their minds overnight if you make it a little bit more complicated for them. But habeas, so that's a very specific application to the Superior Court, and it's quite involved. So the legal question is quite simple, but it takes a lot of resources, and of course, the help of a lawyer to go about that application in an effective way. And so, even though immigration detainees now have the right to access habeas corpus, in the past they did not. Even though they now have the right to access this application, that's not really a meaningful safeguard, because for so many people it's out of reach. And yet, these safeguards are so important, because as soon as, they don't just act as a carrot, they also act as a stick. So, sometimes, because CBSA has such a wide level of discretion, the minister can change his mind and say, what, actually, that is a good idea. Let's allow for release. That is a reasonable alternative to detention, etc.
Yeah, my comment would be a little bit in the same direction, and also noticing that the habeas corpus it's not necessarily an option across Canada, as we have this in Ontario. Like, it's way more independent in Ontario courts, and it's quite, I would not say the word funny, because it's definitely not a funny thing, but it's quite interesting that you see CBSA going quite active against habeas corpus and other provinces. So as Molly, you're trying to do that. It says a lot of things on how these agencies sees alternatives to detention. When you start, okay, let's move things from the Immigration and Refugee Board and CBSA, and let's move towards provincial courts to seek release. then they say, okay, let's talk over the phone on this issue and try to keep things under our control. But this is very problematic, and clearly says that quite often the way they perceive alternatives to detention is not necessarily being in the community, even on a condition. It's about deportation.
Thank you. And just a reminder for those viewing, please do send in your questions through the Q&A function. And I know that you talked a bit about discretion of the CBSA. I was wondering if I could ask the panel, who decides whether detainees are released or not? What happens to detainees when they are released?
So, I mean, the decision maker is the immigration division. The CBSA makes the case. The CBSA functions kind of like a prosecutor. That's the language that's, I think, more familiar to people. But the immigration division makes the decision. The person is called a board member. So they're an administrative decision maker. And that decision, like Hanna explained, happens, there's a decision that happens after 48 hours, then after 7 days, then every 30 days. And when detention comes to an end in one of two ways, the person is either released or deported, right? So I don't know if João has statistics. I'm not sure that anyone has statistics on the percentage of detainees who are released and the percentage of detainees who are deported. It would also be interesting to know, and I do think there's a PhD student working on a project looking at whether people who are deportable are in the end deported or are released back into the community because deportation has become impossible. That I think is a really important question, because it goes to show us the real hollow purpose of the immigration detention regime. What are we really doing here? If a good number of detainees, it becomes apparent that they're not deportable, and we release them back into Canadian society after, like Hanna referred to, sometimes as long as 11 years of detention in a facility where they're not provided with resources. They're not taking classes, they're not learning job skills. They're really just being held in limbo. So it's horrifying that sometimes those individuals return to their lives having been forced to sort of absent themselves from anything productive or constructive or over the course of sometimes many years.
I did want to mention, Molly, I mean, you mentioned, I guess, the two ways that people are released is through release or through deportation. There is a third way, unfortunately, and that's also through death. I know that Ontario right now is undergoing an inquest into the tragic death of Abdurrahman Hassan, who passed away in an Ontario correctional facility. This is happening actually in December, and it's quite an important occasion that hopefully will reflect not just on the specific circumstances around his death, but some of the systemic issues, hopefully, that led to where he ended up and how he tragically died. I don't know if anybody has any comments around the inquest. I know these are rare opportunities, but if anybody wants to sort of speak about that, and given that it's going to be in the news, I think in a few weeks' time.
I have some data on the detention review outcomes. I don't have this in front of me. I was trying to find the new ones, but it's kind of tricky because usually the Immigration Refugee Board, they put everything together, and the same person may be subject to 10, 12 or more detention reviews if they are longer than a year. So it's hard to know what really is the trace back to individuals in terms of release, but the outcomes of these hearings, like 90% is to remain detention. Like this was over the years, like the last 10, 15 years, something like that. 5% failure to appear somehow, which means that someone is deportable because it's not present to this procedure, and release permission to enter in Canada, it's 1-2%, and then you may have like a 3-4% with release under conditions, which means that it's hard to know the cumulative thing, but we're not releasing from detention as permission to stay in the country. So this is not the big numbers like at all. The big numbers is to stay in detention, and at some point this become converted to a deportation, sadly.
Another question is, we've seen that some immigration detainees are held in jails while others are held in immigration holding centers. Which detainees are held in jails and how are these decisions made?
So I've been working on a project with the Canadian Association of Refugee Lawyers on this point. So this is a good moment to plug that project. The way that decision is made, it's by the CBSA, and they have a tool called the National Risk Assessment for Detention, which gets abbreviated to the NRAD. And every detainee is supposed to be subjected to an NRAD. And how the NRAD works is the detainee gets points for various factors, and those points are added up. And based on the total of those points, the detainee is either detained in an immigration holding center or a jail, or they fall somewhere in the middle ground, and the CBSA has the discretion to decide where they should be held. Now, that being said, Hanna showed a map at the beginning of the presentation. Immigration holding centers only exist in BC, Ontario, and Quebec. So any detainee who's detained in another province is automatically held in a provincial jail, regardless of their NRAD score. The immigration holding center is only an option in those three provinces. So there's some geographical randomness to where an individual is held, which is highly problematic and something that Carl, the Canadian Association of Refugee Lawyers, is concerned about. And we've been doing research in the hopes of changing how these decisions are made and advocating such that detainees are detained as little as possible in provincial jails. The ideal would be that they're not detained in provincial jails at all, but it remains to be seen what's sort of in the realm of the possible. Hanna's project and the advocacy that Human Rights Watch and Amnesty International are doing is essential, I think, to this. So yes, this NRAD is applied to the detainees to circle back to the technicalities of how this works. And the detainee is placed in either a holding center or a jail, assuming that a holding center is available. And they're supposed to be reassessed every 60 days with that same tool. Detainees can be transferred. I don't think, have I ever seen, we definitely see transfers from holding centers to jails. I don't know that I've seen a transfer in the other direction. What's also important to know is that NRAD is one of the least opaque processes I can think of in sort of Canadian immigration law, that it's not disclosed to the detainee's counsel. It's generally not disclosed to the detainee, him or herself. The detainee is not given an opportunity to participate in that process. They're not asked about their input. And NRADs are notoriously, to the degree that they've been divulged to lawyers or the public, they're notoriously rife with errors, with misunderstandings, with a lack of evidentiary foundation. They're done on a very quick basis. Someone is detained, this paperwork is completed, and they're potentially sent off to a jail for years. And they're virtually impossible to challenge because the detainee doesn't know where his or her NRAD is. The lawyer often doesn't have it. So in order to challenge it would be quite complicated. One would have to go through some process in order to get it, and then challenge it to the federal court. And the power of the federal court is simply to say that NRAD was completed unreasonably. We're going to send it back to be recompleted again. Now, as far as I know, that kind of legal challenge hasn't occurred yet. And again, Carl's looking at whether that might be possible in order to sort of improve the way this NRAD is engaged in, and to make it more transparent and to increase participatory rights for detainees. But there's so many problems with the way this placement is carried out.
And regarding,
go
ahead. I would just mention quite quickly on the geographical side, because there is the geography by province, but I would say also by airport, because it's really nearby the airport. Like in the Quebec facility is 30 kilometers, Vancouver as well, the Toronto facility, it's barely 8 kilometers. So after the parking lot of the airport, you're pretty much in the detention center. And in terms of capacity, is not a lot. So there's also the bureaucratic side of it, that if it's not if you are in the same province, but you're not nearby these facilities, more likely you're going to end up in a correctional facility of the province. And if it is, there's no availability in the detention center, in the immigration holding center, they're not going to hesitate to send you to a provincial facility.
And if I could just go back to the NRAD, I mean, this is really a 2-page form that's largely a series of checklist questions that are yes or no or different, you know, so it's a very simple form that has huge repercussions. But beyond that, that's really the tip of the iceberg of CBSA's, you know, showing their work, showing how they arrived at a particular decision. Because in reality, they have a lot more discretion over these decisions. And so, for example, one of the things that came out of our research was that in certain circumstances, CBSA will hold immigration detainees with mental health conditions or psychosocial disabilities in provincial jails, specifically in order to provide access to specialized care in those provincial jails. So the justification for holding somebody in a more restricted environment is that in an absurd way, they have access to healthcare treatment. Of course, you know, we had a recent independent review of solitary confinement practices in Ontario jails, and that review found that specialized care amounts to essentially solitary confinement. And generally, I don't think it's a complicated notion that you don't go to jail to access healthcare. You know, that's a very sort of absurd justification, and yet that's the policy, right? That CBSA you know, claims that they cannot manage the behaviors, so-called managed behaviors of detainees in immigration holding centers, which are also medium security prisons. They resemble and operate like medium security prisons. So that in itself is also problematic. But they, further than that, feel the need to place people in even more restrictive conditions where they effectively relinquish control over conditions and essentially hand them off to the jails, where we know very well that oftentimes people are simply put into solitary confinement, where their mental health is harmed even further. And of course, after the 15-day mark, solitary confinement constitutes torture. And so we, you know, beyond the NRAD, you know, all of these sort of these decisions don't really show up at the tip of the iceberg, which is what we see, and even when we do receive the NRAD forms.
Thank you, everyone. I know that we're sort of coming close to the end of our time. I was hoping to give our panelists maybe some time for any sort of final thoughts that they want to leave before we end the event. Otherwise, sorry, go ahead, Hannah.
Oh, I mean, just as a sort of final thought, I think really ultimately this really does come down to, you know, this doesn't reflect what Canada prides itself to be. This is not who we're supposed to be. This is not the reputation that we're striving to uphold. And it's really devastating to watch how much people suffer and how much people hurt, you know, under the shadow of you know, the big Welcome to Canada banner that we want to hold up as a country. And I think that we can do better. I think we must do better. I think there are important steps that are easy, relatively administratively feasible, at least. And I think that we should work hard to hold our government to account. I think it's well past time to do that.
Yeah, and I'll just add, sorry, I was reading a question or comment by one of the participants, which I think, how is the question phrased? It's a good one. Is there any hope for shifts in policy at the federal level? And I think I agree with everything Hannah just said. And I also think it's important to remember that in recent years, there's been a lot more reporting and sort of attention paid to immigration detention than in the years previous. There's been an independent audit of the the detention review hearing system. And this report by Human Rights Watch and Amnesty International is another example of, light being shone on the problems with this system. And I do think our government is aware of these reports. I think our government pays attention, and I don't think our government wants to be seen to be engaging in these human rights violations. So I think that, the work of these organizations is essential, but also just even individual Canadians, to the degree that these kinds of questions can be raised with a local MP or in the context of sort of any political organizing, it's always helpful to draw attention to this really important issue. So yeah, and thank you so much to people like Hanna and Samer who work so hard on the advocacy side. It makes such a huge difference.
Yeah, I would like to add that it's really important, the report you released this summer. It's not easy to gather information on detention conditions in immigration centers. We have some data available from CBSA, like general data, but like this general data indicate a couple of things, but having access to what's really going on inside is quite hard. I'm a part of a research initiative called Prison Transparency Project that we're dealing exactly with these issues of accessing to information in not only in prisons, but immigration and other forms of detention. It's not necessarily the difficulty of assessing the data is not necessarily restrict only to immigration, but also to other sides. But like immigration has additional problems because some of these release means deportation. So like having access to what's going on, you need to get the information while you can still have contact with detainees and former detainees in the country. And it's not necessarily easy. And I think like the work Molly is doing as well on the locations will also show that. Like one thing is assessing the immigration detention, but when you go to the provincial side, this may raise other difficulties as well, as information is going to be more sparse and so on. And I really hope we continue shedding some light on the carceral conditions and human rights violations in such detention centers.
Thank you very much. And if I can make one pitch to those who are watching today, please do check out our campaign website. It's been posted in the chat where we have more information, including how you can get involved in the campaign to end this horrible practice. But really want to thank not just the organizers, but our incredible panel today. That was an incredibly informative discussion, and thank you for taking so much time to discuss this. I think we'll just leave it at that. Thank you.
Thanks, everyone.
Thank you for having us, and thanks to all the attendees.
Thank you.